Thank you again for coming, and if you'll all please rise as we welcome the Governor of the U.S. Virgin Islands, the Honorable Kenneth E. Mapp, and Lieutenant Governor, Honorable Osbert E. Potter.
Good morning. Please be seated. We do know we have a press conference getting ready to start. We have a swearing-in that's scheduled to start at 11. We apologize for being late. We just concluded a meeting with the members of the 31st Legislature, and we'd like to take this opportunity to report to the people of the Virgin Islands the information that we just provided to members of the Senate. As it is full knowledge, I recently returned from a business trip to New York City. In mid-August, I received a telephone call from Attorney George Dudley, representing the Hess Oil Company, advising me that Hess Oil had acquired, or believed they had acquired, a buyer for a portion of the refinery assets at Estate Hope on St. Croix. Hess Oil and Lazard and this potential purchaser wanted to have an opportunity to meet with me to discuss the tenets of the proposed sale and to discuss the obligations due the people of the Virgin Islands. In attendance at the meeting in New York on September the 8th, Mr. Andrew Chang represented the Lazard Company, Attorney Curtis Mellett, David Bayrock, Roman Brzezinski, as well as a Mr. Carlos Rocio, and Jesus Malpica represented PDVSA, while Hess was represented by its Senior Vice President, Mr. Tim Godell, its refinery manager, Mr. Brian Lever, its attorneys, Mr. Nick Bruntas and Attorney Alfred Wong, as well as Attorney George Dudley. The discussions with Hess Oil centered around the potential purchase of the docking, terminal, storage, and racking facilities at the Estate Hope plant. The principals, Hess and PDVSA, introduced me and my team to an entity called ArcLight Capital Partners, LLC. ArcLight Capital, from the summary investigation of our financial advisors in New York, is a leading energy-focused private equity investment firm who intends or have created a Virgin Islands-based company. ArcLight is based in Boston, Massachusetts. It is a 29-person investment team and a 400-person asset management affiliate. It has invested approximately $13 billion in 90 transactions since its inception in 2001. In addition, it has raised 6 funds and owns or has owned interests in 19 midstream companies. Most recently, it raised $5.6 billion of investment dollars. ArcLight Capital Partners, LLC investment focus is on large midstream infrastructure in the energy industry. It owns storage terminals, pipelines, and processing systems. It is spread over 6 affiliated entities in North America. It owns approximately 100 million barrels of storage capacity, 19 terminal facilities, and 9 miles of oil pipelines. ArcLight is very interested in purchasing the asset facilities at a portion of the refinery of St. Croix, and Hess advises that the purchase price for that segment of the asset is $190 million. In addition, currently and readily available is 13 million gallons or barrels of storage capacity with up to 30 million gallons of capacity to be available. It will house the finished crude products such as gasoline, jet fuel, propane, liquid propane gas, etc., at the facility for its clients, and ArcLight is also prepared to purchase some of that inventory from its clients and make it readily available to the people of the Virgin Islands, as had happened in the past with Hess Oil. The remaining assets of the refinery will remain available for sale, and ArcLight does not foreclose any opportunity to purchase it, and Hess has no objections to selling it. At the outset of the discussion with Hess Oil, and their offer to the territory to go through this transaction is Hess has offered to pay its $40 million for the contamination monies that are due to the people of the Virgin Islands. It intends and wishes to place its facility in bankruptcy and do a 363 bankruptcy sale on those provisions of the asset that ArcLight wishes to purchase. And then the government of the Virgin Islands would be left in a bankruptcy court to pursue monies due to it. One, the commission payment pursuant to the sale under Act 7576, which at $190 million means that the government would be entitled to $38 million, and the current offset of the property tax abatement at $7 million a year mean that the government would be due another $14 million, so that as of today, out of Act 7576, the government would be due a $92 million payment, for which Hess is prepared to commit only to paying $40 million. And then we would be left as a people and a territory to determine how we would receive the balance of our monies due to us and whatever other obligations are due and owing to the people of the territory. In my conversations in New York, I said to the principals, I expressed my disappointment and my offense personally that a company would come to the people of the Virgin Islands after doing 50 years of business with this territory, ask for our assistance in providing a sale of an asset by asking the territory to reduce the property tax obligation to the company, and in consideration of doing that, also to receive a payment of a commission, and at the time of the sale, Hess not being prepared to make good on just those basic obligations. So I cannot proceed in that basis. And I said to Hess that at a minimum, the people of the Virgin Islands would insist on receiving all monies due to it under Act 7576 and the Fourth Extension Agreement. We would want a deference and a settlement immediately of both PDVSA's and Hess Oil income tax claims in the tax court, and Hess's obligation and commitment to continue its remediation under the contamination settlement agreement with this territory, and we would then be prepared to talk about a release of claims for Hess Oil. I am pleased to say this to the people of the Virgin Islands, that we view this issue in three different matrices. One, the transaction and sale of the terminal, storage, and racking facilities can occur, notwithstanding our dispute. Number two, Hess must make good on all of its obligations for the people of the territory, and we would not include any waiver of its rights or of its responsibilities or obligations to the territory under a sale arrangement. And three, Hess must fulfill its obligation under the remediation and contamination agreement. The attorneys for Hess Oil asked if they could go to their principals and discuss those matters and get back to me. Last Friday, my attorneys received a call, and I was advised that Hess still would like to proceed with the filing of its bankruptcy. It would discuss prioritizing the reimbursement of the pilot. It had very little conversation on the commission fee, and it would discuss the offset of the income tax refund claims. In consideration of Hess's return to me, I am advising the people of the Virgin Islands that at 8:30 this morning, the government of the Virgin Islands has filed a civil action against Hess Oil Corporation in the Superior Court of the Virgin Islands, seeking a 100% return of all of our tax exemptions and incentives given since 1965. This amounts to approximately or in excess of $6.5 billion. Let me be clear. This is not a game, and this is not a thought out of my or Lieutenant Governor's thinking or thought process. There have been a number of cases on the U.S. mainland where states, cities, and counties have entered into transactional arrangements with private companies for investments and economic activity in their jurisdictions. These companies who have breached these arrangements have been sued by the various jurisdictions, and we have found in the courts across America, and while the cases are all individually different, in courts across America, governments have been prevailing in their suits for return of their incentives to companies who have failed to live up to their obligations. Hess Oil has provided tremendous economic benefits to this territory, but the people of the Virgin Islands have bent over backwards to ensure that this company be profitable and that it could operate. We have even floated $475 million in private activity bonds, reducing their interest cost on some of their capital at the plant from 14% and 15% per annum to 4.25%. Hess has obligated itself to provide economic activity to this territory on a minimal amount of its operations of at least $150 million a year up to the year 2022. Without any notice, Mr. John Hess, the CEO, the then chairman and the CEO of Hess Oil, contacted Governor John P. DeYoung Jr. and advised him on February 12th that the refinery was closing, advised him in January that the refinery was closing, and by mid-February the workers would be out and the plant would be shuttered. Hess doesn't get to do that simply by its whim. We will release to the media today copies of the complaint that we have filed in the Superior Court, asserting and showing that while Hess Oil bleeded the Hovensa refinery of cash through management fees and had planned and clearly orchestrated its closure long before 2012, it made a decision it no longer wanted to be in the refining business and really didn't give a hoot about its obligations to the people of this territory. That is not acceptable. And so we will fund this litigation not through the general fund, because that will be to our opponent's advantage. Will the legislature and the people of the Virgin Islands have the political will to continue to appropriate funds for litigation as the need to build schools, to provide security and health care to our people struggle in the paradigm of dwindling revenues to the territory? And so we have decided to finance this litigation outside of the general fund through a contingency arrangement on a sliding scale. The Attorney General in a subsequent forum will be available who will be able to discuss the specifics of the contingency arrangement. Let me say that the normal standard contingency arrangement on civil suits are generally 33% plus litigation costs. We will do this litigation at less than that on a sliding scale because of the magnitude of the dollars involved. And at a later date or a later forum, the Attorney General will provide you with a discussion on these issues. So we have two issues that we are dealing with. One, the transactional issue on the sale of the docking, storage, terminal, and racking facilities with ArcLight, and we have created a transactional team that would be headed by the Commissioner of Finance, Mr. Valdemar Collins, and it will include consultants from the private sector in the energy business, and the litigation side, which will be led by the Attorney General Claude Walker, and the Attorney General will have some involvement on the transactional side to ensure that we are not stepping on each other's toes in terms of the interest to be provided. We have local counsels that are involved with the Department of Justice that are assisting in this litigation. In point of fact, we were on the verge of filing this suit in August when I received a call from Attorney George Dudley advising me of the potential sale, and I wanted to give that an opportunity to hear that and to determine whether we had grounds for settling the issues between the people of the Virgin Islands and Hess Oil. And we have found from our initial meetings in New York that we do not come to a common ground to begin the process of settling these issues. And I, again, as governor, will state publicly that I remain open, but my limits are limited. I will not be a party to waiving the interests, the rights, and the assets of the people of this territory. I think we have bent over far enough. We have bent backwards enough. We have given up enough. And we are not without some level of gratitude for the investments that Hess Oil made in this territory. But in 1992, the Federal Inspector General wrote a report about the benefits to the territory and to Hess Oil. And that 1992 report, if the numbers serve me well, if my memory serves me well, the Federal Inspector General said that the people of the Virgin Islands received a little over $1.5 billion in benefits, and the amount that Hess Oil had received was in excess of $10 billion. And so the difference and the ability of the people of this territory to help that company and to work with John Hess, with Leon Hess on this transaction was a beneficial arrangement. But the current company, in its pursuit of its shareholder value, has made its decisions. And so the people of the Virgin Islands, we have made ours. We are in the Superior Court because we do not view these issues as simply contract issues between two parties. These are issues of law. Act 7576 speaks specifically to property tax payments. The economic benefits to this territory are matters of law. The legislature of the Virgin Islands codified these specific privileges and benefits for the condition of investment, jobs, and economic dollars flowing through the economy of the territory. And so we will move forward with our case at the Superior Court. There will be much coming out of the Department of Justice. We have invited the legislature to convene a hearing and have the Attorney General and the legal team on this case come before the legislature and have a conversation on those issues that it can discuss without detriment to the claims on behalf of the people of the territory. This is the result of my meetings with Hess Oil, and I should point out that my conversation with the representatives from PDVSA, Mr. Jesus Malpica, he specifically asked me particularly on the income tax claims, the income tax refund claims on behalf of PDVSA, that I reach out to the president of Venezuela and have a conversation with him on those matters. As you know, the PDVSA company is owned by the government of Venezuela, and I will be making that call sometime today. In furtherance of this conference and wanting to move on to the swearing-in, we are now open for any questions that you may have. No questions? Okay. I thought you were going to let me off.
Governor Tom Ader, St. Croix Avis. Yes, sir, you mentioned the payment in reference to the contingency arrangement on a sliding scale.
Yes.
Could you please elaborate where would the money come from to fund the litigation?
It will come from the law firm Cohen and Milstein out of Washington, D.C., who will fund this litigation on behalf of the territory. The contingency fee will provide that anything up to $100 million would be, I'm sorry, I was saying Act 7576. I should correct that to Act 7566. I apologize for that error. The contingency arrangement provides for benefits up to $100 million. The contingency fee will be 28%. Benefits of $101 to $250 million would be at 24%. Benefits in excess of $250 million will be at 20% plus the cost of litigation. The Attorney General will be responsible for authorizing the cost of litigation.
This morning, Governor Ernest Gilbert VI Consortium. In relation to ArcLight, the company that intends to purchase the oil terminal, were there any discussions in relation to employment, how many people it intends?
Yes. Well, ArcLight's proposal, and I want to be very clear that this is a presentation. We will now enter into the transactional discussions to determine if we can establish an operating agreement. On the 13 million gallons, and if I'm mistaken, someone correct me, is it, on the 13 million gallons, they would propose to hire 70 persons. And then on the improvements, on the infrastructure improvements and development, there would be more. That's their proposal.
Any projection in relation to how soon they may?
No, that is going to be determined based on our ability to enter into an operating agreement.
Do you anticipate that an agreement may be forthcoming?
Well, from the discussions we had with ArcLight, I think the synergy is really very good. I think we have the facilities beyond any in the Caribbean in terms of size. ArcLight's affiliates in terms of this segment of the energy industry is really number 2, and number 1 is in the region. And I think there's great synergy there, and I think that we like what they presented. And certainly they're not interested in purchasing if an operating agreement could not be had with the government. And as I said to the members of the legislature, that we asked the question and they would like to have at least a final answer, which would include legislative action by November 15th. Now, that is not a date that is in stone because first we have to get involved in negotiations, see if we can arrive at an agreement. And I, being a graduate of the legislature, and so the Lieutenant Governor, we are graduates of the legislature of the Virgin Islands, we would like to give the legislature adequate time to vet any proposed operating agreement so that their questions are answered and that the people of the Virgin Islands understand the tenets of any potential operating agreement that would bind them and economic incentives going forward. Yes?
Oh, no, my question before was kind of part of what you had to ask about ArcLight. But why, since this is just a proposal, why did you want to provide this information since they haven't really finished with the negotiations and the operation agreement part of it?
Well, I don't believe that we provided any information that should not be provided, and I think that had we been able to work out our issues with the entity Hess Oil, we may have not given out all of this information today. But because of the position that Hess Oil has taken and our need to pursue the responsibilities and the rights and privileges on behalf of the people of the territory. And let me add that the offset of the property tax payment, I have directed the Attorney General and the tax assessor to immediately file a property tax lien against the assets at Estate Hope, because even in bankruptcy, you cannot shield your tax obligations. And we are not going to join with any other creditor on Hovensa for taxes and commissions and monies due to people of the Virgin Islands. So we do not feel that any of the information that we have given out has any impact or negative impact on any potential transaction on the sale of the assets I have described. One final question?
Yes, one final question. And so Hovensa gave no information as to the status of the refining portion of the refinery?
We haven't talked to anybody in Hovensa. We are dealing with our original partner in this transaction, which is Hess Oil.
Right.
And as you know, and the people of the Virgin Islands know, Hess Oil has asked for a number of amendments, including the fourth amendment that was ratified by the Senate to their original agreement. They claim that the plant, the remainder of their facilities is up for sale, and ArcLight has indicated that while they do not have an interest now in purchasing it, they don't foreclose the opportunity if it should present itself, and there may be others who are interested in it. So but the question is, does the plant sit there and blow away in the wind and contaminate the rest of St. Croix and not be mitigated, and that the affects of it being there are not put in some order, including the possibility of taking it down? I'd like to thank you all I'd like to thank the members of the media, and thank you for giving us the opportunity for coming before you and the people of the Virgin Islands to report on our meeting with Hess Oil. I'm sorry, so it is 13 million barrels, 30 million barrels, so let me make sure I'm clear on that. Not 13 million gallons, 13 million barrels, up to a maximum capacity of 30 million barrels, all right? It's so many millions. I'd like to thank you all. I would get on, Kim, you can start making arrangements. We'll fold right in to the swearing-in ceremony.